Welcome to Employment Law This Week. I'm George Whipple. Does denial of remote work constitute disability discrimination? The Southern District of New York says no in a decision that offers clarity to employers. Epstein Becker Green's Eric Emanuelson is here to tell us more.
On January 2nd, the Southern District of New York held that an employer's denial of an employee's request to continue working fully remotely as a disability accommodation does not constitute disability discrimination under the Americans with Disabilities Act or the Rehabilitation Act. The court emphasized that the employer had engaged in the interactive process and offered multiple reasonable accommodations, including partial remote work, additional breaks, ergonomic equipment, and transportation assistance.
Eric, what does this case tell employers about how to approach remote work accommodation requests in the post-pandemic workplace?
While the COVID-19 pandemic expanded remote work and raised employee expectations, it did not permanently redefine all jobs as capable of being performed from home. The decision reinforces that work from home can be a reasonable accommodation in some situations, but employers are not required to maintain pandemic-era arrangements or approve new remote work requests if they can show that in-person attendance is genuinely necessary. The key is being able to clearly articulate and support with specific examples which essential job duties require an on-site presence.
So communication and orderly process are critical.
When employers follow this structured approach for their interactive process and offer reasonable alternatives, the denial of full-time remote work should not by itself give rise to liability under the ADA or Rehabilitation Act. However, it's important to note that while the court dismissed the employee's discrimination and constructive discharge claims, it allowed her retaliation claim to proceed. This is a reminder that even if denying an accommodation is legally justified, the timing and circumstances surrounding that denial may still create liability for employers.
Thanks, Eric, and thank you very much for watching. We'll see you next time.